Okay, we're going to get started here. I'd like to introduce the members of our panel first. We're presenting on intellectual property issues in web publishing. Our first speaker is Trotter Hardy. He's a professor of William and Mary. Then we're going to hear from Susana Darwin, who works at Encyclopedia Britannica. I'll be speaking. I'm Deb Quentel with CALI. And then finally, Mary Dicig, who's an attorney here in Chicago with Gardner, Carton, and Douglas, will be speaking on some of the problems. Thank you.
Thanks, Deb. I find that whenever I have to give a talk right around lunchtime that I have a heck of a hard time staying awake. And God knows it's probably harder for you. So what I'm going to do is try to give you a blitzkrieg overview of intellectual property. And I figure if you can't stay awake during a blitzkrieg, you're hopeless anyway. So let's get started. I want to tell you how to think about intellectual property. When I say intellectual property today, I'm really meaning copyrights and trademarks. Patent law is a part of it, but for practical purposes, patent law is not all that relevant to most web issues. So I'm really talking about copyright and trademark. The way you want to think about it is in terms of three things. The first of all, it has certain subject matter. All intellectual property has certain subject matter, stuff that can be protected. It also has certain rights associated with it. If someone owns a piece of intellectual property, they have certain rights they can do. They don't have all possible rights, but they have a set of defined rights. And finally, there's a concept of infringement. Now, rights and infringement are often simply the flip side. The exercise of someone else's rights without permission is typically an infringement, but not always, and there's a little bit of divergence in the copyright area, and I'll try to show you some of that. Let's talk first about trademarks and trademark subject matter. There's a trademark statute that defines federally registered trademarks as any word, name, symbol, or device that can be used to distinguish the goods of one producer from another. And the same thing applies to services as well, goods or services. The breadth of things that can be trademarks is very, very wide, I think wider than most people realize. You're certainly aware of things like logos in terms like Exxon and Kodak and stuff like that, and Xerox as being trademarks. Symbols and pictures, things like golden arches, either the phrase or the image of golden arches are potentially trademarked. I don't know if McDonald's treats them as a trademark, but I would guess that they do. And then finally, if I say to you, dum dum dum, or sorry, dum dum dee. It's supposed to be dum dum dee. You would recognize that, right? You know where that's from? That's NBC's thing. That's trademarked. Those three notes are a trademark of NBC. So lots of stuff can be trademarked. All right, that's the idea of the subject matter. Then the next question is, what about the rights? What does the trademark owner have rights? It's not particularly well defined because it turns out not to be nearly as much of a problem with trademarks as it is with copyrights. But basically, the trademark owner has a right to use the mark in a way that identifies the producer as either the source of the product or as a symbol of consistent quality. And what that means is if you see a trademark like Twinkies, it may tell you who the manufacturer is. It may not. But it may just tell you that all Twinkies are alike, and that's enough. The consistent quality doesn't have to be high quality; it just has to be consistent quality. All right. So there, it identifies the owner as the source of the good, or it identifies consistent product quality. The trademark infringement is really bottomed on a single sort of concept, and that is the likelihood of consumer confusion. The consumer in question is whoever the relevant consumer is. So it's not, I don't just mean like consumer products. In a lot of industries, there are trademarks that only mean things to people who are in the industries. If you're buying x-ray machines, the consumer is the hospital or somebody like that. So it's just something who the relevant market is. And if people in that relevant market are likely to be confused by some sort of trademark, that's the essence of trademark infringement. Confusion can range from two ends of the spectrum. The most obvious type of confusion is what trademark people call passing off. That's where the guy's selling the watches that says Xerox and they aren't, Rolex, and it's not really a Rolex watch, and they're trying to say, yeah, here's a Rolex watch, and it's not. That's classic passing off. That's a pretty obvious kind of thing. The other end of the spectrum is something that people don't understand quite as well, but there is such a thing as confusion of sponsorship. So if you see Coca-Cola on a T-shirt or a sweatshirt, you're not confused into thinking that it's a Coke, and you don't really try to drink the T-shirt, but you may be confused about who has sponsored or authorized the sale of those T-shirts, and that's another kind of confusion. It turns out, for various reasons, that for weak trademarks, those that don't have a great deal of recognition, usually passing off is about the only thing that constitutes infringement. So if somebody has Acme hardware or Acme brand soft drink, unless there's a real concerted effort to fool a customer about that brand name, there's not much else that's going to be infringement. But if you have strong marks like Xerox, Kodak, Coca-Cola, confusion of sponsorship is often enough. That's a lesser showing. So you have to talk about the range of weak marks to strong marks when you're thinking about infringements. If there's no consumer confusion of any type, there shouldn't be any trademark infringement. Now, one hesitates to make these kind of blanket statements, but basically if you're using a trademark in a way that no one is confused about the good or product you're referring to, or the sponsorship or the authorization, if no one is confused, it ought not to be a trademark infringement. That's the blitzkrieg on trademarks. Let's go to copyright. Subject matter of copyright, a little more detail. There are several things that are listed in the statute: literary works, pictorial, graphic, sculpture works, musical works, and choreographical works. A very broad range of subject matters, if you think about it, because almost anything that's sort of information is potentially copyrightable. I mean, tunes, songs, graphic images, bits of text. If you do a dance routine and you draw it, that's a copyrightable work if it's an original work of authorship. It doesn't have to be original. You don't have a copyright in something that if you weren't the author of it. But as long as it's original and it's a work of authorship, it's copyrightable. There is no requirement any longer since March of 1989 to put the little copyright notice on something. And at one time in our law, there was a kind of presumption that material was not copyrighted unless the owner put that little copyright symbol on it to say, I intend to protect it. Since 1989, when we joined an international agreement that prevents this stuff, we've changed that presumption. Now the presumption is if anything can be copyrighted, it is copyrighted, and if the author wants to change that, they can put a notice, this is in the public domain. But the absence of any kind of notice has no significance for copyright at all. You must assume that if something can be copyrighted, it is copyrighted. Incidentally, there's no formal step either. It does not require that you deal with the government in any way. If you create a work of authorship, it's copyrighted. I see somebody writing on a pad. If you're writing something down, it's being copyrighted as you go, and it doesn't require applying to the government or doing anything else. It's very, very easy. The rights of a copyright owner are more defined than they are for trademark owners, and there are several, and they're fairly specific in the statute. One is to reproduce the work in copies. To copy it. Right? Another is to perform it publicly, and that applies to those kinds of things that can be performed. And those things that can be performed are things like music, choreography, plays, motion pictures, all those things that are capable of being performed. The copyright owner has the right to control public performances, not private. So if you're looking at a videotape in your home, that's not a public performance, that's not a copyright infringement. But if you take that videotape and put it in a theater and invite people to come in, all of a sudden it's a public performance, that's infringement. All right. In a very similar way, there's the right to display works publicly, and that applies to those things that can be displayed, such as a work of art, a piece of sculpture, a drawing, photograph. Those are things that are capable of being displayed, and the copyright owner has the right of public display, not private, but public display. The copyright owner has the right to distribute the works to the public and to make derivative works, and those are adaptations or changes. And people often say, well, if I get a work that's copyrighted but I change it, is that okay? And the general answer to that is no, because the copyright owner has the right not only to display, to copy, and so forth, but to decide what changes are appropriate to that work, to make derivative works. And a derivative work could be as big a change as taking a novel and converting it into a movie. That's a major change. Or it could be taking a book and translating it into a different language. That's another kind of derivative work. Or it could be taking work and editing it and annotating it. That's another kind of making a derivative work. So there's a range of what's a derivative. Copyright infringement is defined, this is basically the correlative flip side of the coin, any exercise of the copyright owner's rights that isn't either authorized by the owner with express permission or authorized by some provision in the copyright statute itself, which authorizes a lot, by the way. Let's look what exceptions are in the Copyright Act. There's a long list of exceptions, and it constitutes the bulk of the Copyright Act. If you look at the Act itself, you'll find there's a very few pages defining subject matter, very few pages defining rights, and a huge bunch of pages defining the exceptions. All right? Now, those tend to fall into a couple of different contexts. Most of those exceptions are quite specific. There'll be things that cover interlibrary loans, for example. There's some exceptions for that. There are exceptions for showing videos in a classroom and face-to-face teaching. There are exceptions for, my favorite is horticultural and agricultural fairs or exhibitions. So we commonly use that at my law school. Probably you do as well. There are some exceptions about making backup copies of software. There's a lot of them, but they're very specific, and the rules are quite specific, and you have to fall within the rules in order to have that exception apply to you. I'm not going to go into those, not because they're not important, but because there's so many and they're so detailed, there's no way in a talk this short to really give you information about it. But just be aware that there are a lot of very specific exceptions that are defined, many for educational purposes, many for library purposes as well. But the one thing I do want to talk a little more about is there is one very general exception, and that's the fair use exception. And in fact, and all that long list of exceptions, fair use is the very first one. The rest of them are more specific. But that's the one exception that can apply in any context, in any circumstance. The question is, well, what circumstance, what context, how does it apply, and so forth. So let's look a little bit more at fair use. First of all, you have to realize that it's a very vague concept because it's very context dependent. It's decided case by case by courts, and it's very hard to give people advice in the abstract about when fair use applies and when it doesn't. If you read enough cases, you get a sort of a feel for it, but it's not a bright line kind of thing. It's very fuzzy. And what courts do when they decide fair use cases is look at four things that are specified in the statute and consider all those four together. One of those is the nature of the work. Mostly that means, is it highly fictional and highly creative, in which case it gets a lot of protection, or is it highly factual, in which case it gets much less protection. That's what the nature of the work means. The amount that's been taken or copied is significant. If you take 15 lines out of a 500-page novel, that's going to look good for you because that's not much. On the other hand, if you take 15 lines out of a 16-line poem, that's a lot, okay? And it can make a difference. So that's what we mean by the amount. The purpose of the use is important as well, and that tends to suggest or refer to, are you doing it for commercial reasons? Are you trying to make money? Are you doing it for educational reasons, for nonprofit, for scholarship, teaching? That's what purpose refers to. And then finally, the effect on the owner's market. If this conduct were to go on sort of regularly, would it make a serious impact on the copyright author's market or right to earn money? And those are all four things that courts look at in deciding fair use cases. Now, right away, if just you know nothing more than those things, you can spot some popular myths about fair use, and you can disabuse the people who hold them, and it may be yourself. First of all, people assume that if something's an educational, for educational purposes, it must be a fair use. It's for education. It's okay. The reason that that's a myth is that the purpose of the use is only one of the four factors, and you have to look at all four factors. So simply saying it's for educational purposes, that's good, but it's only one factor. You have to ask, well, what effect does it have on the market, how much has been copied, et cetera, okay? Another thing is if you don't charge any money. I'm not trying to make money from this. It must be okay. It must be fair use. But again, that's a myth because a non-commercial purpose, that's good, that's worthy, but it's only one of the four factors. And if you're doing something that would have a serious effect on the copyright owner's market and you're copying a lot and so forth, even if you're not charging money, may not be a fair use. The flip side to that is, even if you are charging money and doing it for a commercial purpose, it can still be a fair use if the other three factors suggest that. And the Supreme Court said that in a recent case involving a parody of Roy Orbison's Oh Pretty Woman. I don't know if you've heard the rap version by Two Live Crew of Oh Pretty Woman, but you wouldn't think of it as Oh Pretty or anything. But nonetheless, they were clearly selling their records, and it was a commercial purpose, and the court said, that's okay, we looked at the other factors as well, and altogether, we think it's still a fair use. All right, so that's no one factor controls. That's what I want to try to stress. Finally, this is not so much a fair use question as it's just a sort of a stupid idea that information wants to be free people hold, and I think those people are fading. That's my view. If it came from the web, it's okay to put it on the web. Well, that's just not true. And you ought to ask, well, if it came from a bookstore, does that mean I can sell it in my own bookstore, or reproduce it? If the bookstore has multiple copies, does that mean I can make multiple copies? And no, it just doesn't follow. It just doesn't follow. In fact, where you got it from doesn't have anything to do with whether or not it's okay for you to use it. Right? You have to think about all four factors. Okay, Now, and to wrap this up, I told you I'd give you the blitzkrieg overview. Intellectual property really has three facets, and you ought to think about it this way. It has a kind of subject matter, what's covered. It has a certain set of rights. What can the owner do with those subject matters? And finally, there's some concept of infringement, which means what can people who aren't owners not do, right? For trademarks, the subject matter is anything that distinguishes one company's products from another company's. The rights are to use the mark in order to identify the producer or to show consistent product or service quality. Infringement is simply doing something that causes consumer confusion, either about who's selling the product or who has authorized or sponsored the product. For copyright, again, that's what you think about is what's the subject matter? It's original works of authorship. And nearly anything on the web fits that definition. As I said, text, images, pictures, graphics, videos, dance, you name it. It's all potentially copyrightable. It's all copyright subject matter. What are the rights? The rights are to reproduce the work, to display the work, to perform the work, to make copies of the work, to make derivative works from the work. So putting something on a website, for example, is a distribution. It can be a performance. If it's a piece of music and you put it on the web, it's a performance. It's probably a reproduction. It's a lot of things. Infringement is simply the unauthorized exercise of the owner's rights, where authorization can be either from the author or from one of the exceptions in the statute, including fair use. Fair use is the only general authorization, hard to predict because it depends so much on the circumstances and the application of all four factors. Bingo. Okay. Might be in a nutshell.
Good morning. I'm Susana Darwin. I'm the manager of rights and permissions and media properties at Encyclopedia Britannica, where Mr. Hardy has just been more theoretical, maybe? Maybe? Sure. Okay. I'm going to be more anecdotal. I'm going to speak from my experiences at Encyclopedia Britannica. I'm going to speak mostly about images and multimedia, but what I say is also relevant with regard to copyrightable text. I want to give you a little bit of background about me, a little bit of background about Britannica, and then I'm going to go right into online rights issues. But I'm going to talk about those with print as sort of the baseline, because the rights that we're securing for online and CD-ROM uses, for better or worse, is rooted in attitudes and practices with regard to print. I've been a photo researcher and a photo editor. Well, I was until this past spring for about 9 years, with the exception of the time that I spent at law school here at Chicago-Kent. I was mostly responsible for, as a freelance photo researcher and photo editor, for securing the rights, for locating and securing the rights for images in fine art to illustrate textbooks, atlases, and other publications, brochures, record covers. And most recently, for Encyclopedia Britannica, I started my position with managing rights and permissions back in the spring. Britannica is available currently in three formats: in the classic print version that everybody knows and some people love, the CD-ROM version, and then there's a subscription service for online. All of these overlap very heavily with regard to content, but they're each one presents information in a slightly different way. I mean, it's rare. I mean, with the exception of laptops, it's sort of hard to take the Encyclopedia Britannica to bed with you from online. However, you can pull, volume 22 and stay up all night reading about immunology if you wish. I started 2 years ago at Britannica, and I was originally going to be working just on the print set. Went immediately into working on their publicly accessible websites. These websites have ranged from the American presidency to Black History Month to Women's History Month to the Nobel Prizes, and we just launched one on the Normandy invasion, somewhat to coincide with Spielberg's movie Saving Sergeant Ryan. Is that what it's called? Sure. Okay, that's what we're going to call it. It's a working title. The sites are separate from the paid subscription service. And they're available for a short period of time, usually 3 to 6 months. The purpose of the websites is twofold. One is to attract attention to Britannica products by drawing material together in sort of a new, cohesive way. So, for example, the Nobel Prizes site, we had hundreds and hundreds of articles about Nobel Prize winners, about Nobel Prize concepts, articles written by Nobel Prize winners that we pulled together as a cohesive site. And so the point of that was just to attract attention to Britannica Online, Britannica CD, and Encyclopedia Britannica. The other purpose is to enhance our content. So, for example, prior to Black History, the Black History site, the Women's History site, our coverage of people who are not white men was fairly anemic, and we've rocked the balance a little bit since then. So it's secondary to attracting attention, and essentially it's advertising. But it's extremely heavy content advertising, and the response has been quite good. Now, obviously, one thing that you can do online and on CD that you can't do in the print set is you can include multimedia items. We've increased enormously the amount of video, of audio that we use, of animations. We have some really tremendous animations of dinosaurs to how cross-country skiing works, which appeared on our Winter Olympics site. Okay, now I want to get into the online rights issues, but let me start with print so that you have an idea of where we're coming from. In the print realm, both in text and in images, the handling rights has been routinized for many, many years. Rights information departments at publishing giants typically are staffed by new college grads who are getting a toehold in the publishing business. I mean, it's extremely routinized. And the rights for still images have been handled by custom, mostly by invoice as contract for decades. And so, for example, for the rights that you seek in print, you figure out what the image is, you find it in print someplace else, or you have an idea of what sorts of agencies or institutions would have the type of images you want. You place your order. Stock photo houses can turn your order around in a couple of days. Museums, for example, can turn it around in a few weeks. And if you're ordering from the Library of Congress, you may get your first Social Security check before you get your images from them. But generally what happens is you specify the rights that you're going to be requesting for this publication, for your book, from the get-go, so that if the supplier that you're ordering from has problems with the type of publication that you're putting together, they can decline to send you the images, and that way you don't have to worry about it. So, for example, at the beginning, you would say that you want one-time, non-exclusive English language rights on a print run of 100,000, because you're optimistic, for distribution in North America. And what that means is that because it's non-exclusive, you're not saying, I want to be the only person on this planet that's able to publish this image. You want only English language rights, because you don't intend to publish in Hindi or in Tagalog, that you only intend to distribute in the United States and Canada. That's you're limiting your territory. And what will happen then is that the supplier will then base its price for the image or images on the rights that you've requested. Now the fees can vary widely depending on the usage. So for example, commercial versus educational, whether it's appearing in color or black and white, the size of the page, whether the image appears inside the book or on its cover. But generally you can predict what the prices are going to be based on the rights that you want. And once you go about securing the rights, it's very simple. I mean, essentially you can have a contract signed by both of you. You can have a countersigned letter. You send them a letter saying these are the rights we want. They send it back with their signature on it, and that serves. An invoice, a simple letter from them saying we're granting you these rights. Just some document detailing the aspects of the rights that you want. For the most part, flexibility and patience are sort of how the industry operates. On the other hand, electronic. There are several things that are different from print with regard to election. First, electronics breaks into three areas right now. There's broadcast radio and television, which I'm not going to address at all. There's the internet, and there's CD-ROM. And of these three, CD-ROM probably bears the most resemblance to print because you've got a discrete, tangible item that you create in a limited number of pressings as opposed to a print run. So if you've got 100,000 books, you could have 100,000 CDs. And you've got a particular targeted area of distribution. The website, the website renders the idea of pressings or print runs irrelevant because there are any number of people that could access it, whether it's by subscription or by creating a free website. And the territory is worldwide by definition. So where you might pay less money to distribute only in North America, you now have to purchase rights for worldwide distribution. You can still limit it to English language because your website is in English, but you need to figure out some other delimiting factor which would be analogous to a print run, and usually that's time. It's very rare to have a supplier comfortable enough to grant you rights in perpetuity. And even if they do that, you may be paying for far more rights and for a far longer time than you need. I mean, if you don't care, if you're not planning to keep the site up after you die, why would you pay for perpetuity? You may only want it for 5 or 10 years. And generally speaking, rights for 1 year, 5 years, 7 years, or 10 years has been typical in my experience. Now, where the fees for print are fairly standard and fairly predictable, I continue to be stunned by how widely they can vary for online or electronic uses. I've literally seen hundreds of % differences between one usage that you actually pay for. I mean, let's just leave free ones aside. Hundreds of % differences between what you'll pay for the exact same rights for one image and another one. Now, the contributing factors for the expense and for the variety is that people are really anxious about the fate of their material online. You know, is somebody going to download this image and abuse it? Is somebody going to download this video and do something awful to it? And so, yeah, sure, they could do that. You know, I'm not going to lie. But by the same token, they could take the publish and scan the image at a higher dots per inch rate than we're actually presenting it. So they may actually get a better copy of your item just by scanning it. And so people's comfort level with print should be brought along and should be injected to how they approach or address online. So things that we do at Britannica to allay people's anxieties, there are actually 4 things that you can do. One is we only present images and video at 72 dpi, which looks fine on screen. It's not great for downloading, but you can see what's going on. You can see the image just fine. Second, what we do is we embed a watermark, and the watermark is actually the Britannica thistle, and it's basically transparent. But what it does is it damages the image just enough to say to the user, look, you know, 1, somebody owns this, and 2, you shouldn't use it, and 3, if you do try to use it, you've got this thistle in it. So you've actually damaged the image to deter usage, and so you can see what it is, but it's still got a mark in it. There are actually also encryption codes for blocking or tracing unauthorized uses that are being developed right now. And the last thing that we do with video is, it would be one thing if you're going to have 2 hours to 15 minutes, as you said, of Rebel Without a Cause on your website. Now the download time, we're not even going to talk about that. But suppliers are much more comfortable if you say to them, you know, we're only using 60 seconds, we're only using 90 seconds of material. And so, you know, you're limiting the amount of material that you're grabbing from the original. And so these factors altogether seem to sort of allay the anxieties that people have about their material appearing on the web. Now, I'd like to offer some guidelines, just in case you happen to want to put up a website. First of all, if you didn't take the picture or didn't make the recording yourself, don't use it online without securing the permission of the person who did. You may have to get the permission of anybody appearing in the image. You don't always have to do that. Sometimes you'll have model release images. That means that the person gave permission, just kind of waived all interest in the image. And with regard to music, there's extra care that you need to exercise. So you may have to contact the composer, the lyricist, the performer, the distributor, and others. I mean, there may be others that have an interest in the work. If you did take the picture yourself, but it's of somebody else's work, again, don't use it without securing their permission. And you may have to also secure the permission of the person who owns the work. So, for example, let's say you're in the Museum of Modern Art, and the security guard has his back turned, and you take a picture of a painting by Alice Neal. You may have to get the permission of Alice Neal's estate, the Museum of Modern Art, and let's say that they don't even own the painting, but it's hanging there when you take the picture. You may have to get the permission of the person that owns the painting. Let's say it's Cleveland Museum of Art that owns the painting, but it's on loan. So there are any number of people that you may have to secure permission from before you can reproduce the image. And I'm not saying you won't be able to ultimately, but you're probably going to pay a lot of money. Also, don't assume that if you get, say, a slide or a print from some institution, that they're the only people that have an interest in that image or in that item. You should at least ask. So let's say you've got a library that supplies you of, you know, Dorothy Parker reading a poem. Dorothy Parker's estate probably owns an interest in it, and there may yet be others who have interests that are not immediately apparent. When you're requesting permission for illustrative material, whatever kind, you know, whether it's text or image or audio or video, specify the language that you're going to be presenting it in, which is obviously, with this crowd, probably going to be English, how long you plan to use it, the context of the use, and whether there are any access restrictions to use. So for example, if I'm going to put something on Britannica online, that's a subscription service. That's going to have an impact on how much we're going to have to pay a supplier for the item that we're getting. If it's going to appear on the public side, on a public site that we put up, that's going to make a difference because there's a much wider availability to the public. Include credit lines, except in commercial context, unless they ask for it. I mean, in the industry generally, if you're putting together an advertisement, you don't include a credit line. So, if you've got the Dalai Lama appearing on an ad for Apple computers, and it's an illiterate ad, think differently, you won't see a credit line for the photographer. You almost never see that. But in an editorial context, always include credit lines and include them consistently. So if you have an image and you have the credit line next to it, everybody should be that way, or have a credit line page. Just be consistent. Consider how many times you're going to be using it. If you intend to use an image in an editorial context and then you're going to be advertising using the same image, say so. Don't make them come to you and say, hey, look, you're using our image for advertising, but you only paid for editorial. And then again, to allay people's anxiety for web use low resolution, embed a watermark, consider using encryption, add the credit line, make sure that the credit line is there, and limit the time of audio or video. And I'll be happy to answer questions at the end. Thanks.
Hi. The reason I got the idea for this topic was there was a posting on Technoids a couple months ago where someone, and I'm sorry I don't remember any of the parties, someone was given a large block of materials by their faculty member and asked to post it all on the website. And the question came up, what sort of problems does that raise for you? What are your guidelines? So what I'd like to address, dealing with our theme of on the road ahead, or preparing for the road ahead, my theme is dangers on the road ahead. And some hooligan here has gone and written all of our beautiful sign. Just one of the reasons, things that can go wrong. What I'd like to address specifically, moving from Trotter's overview of copyright and trademark, is two issues in trademark, and then the second is misappropriation. And the nifty thing about doing a presentation talking about trademark problems is you get to download everything you want from the web, and suddenly it has value. So this is my very own welcome to Babylon 5, but now I've renamed it Welcome to Deb's. So welcome to my space world, if you will, where I've infringed my heart's content. It's amazing what you can quickly find out there and what hooligans can badly mess up with paint. Pardon me for booming. I really don't need a mic. All right. The basic result here is at the basic level, trademark and misappropriation prevent you from unfairly benefiting by using something that belongs to someone else without permission. This is a very layman's version of what the statutes in copyright and trademark specifically deal with. You can't, if you work from the premise that everything is owned by someone, you need permission to use everything. Now, what within getting permission sort of are our guidelines? What does trademark protect? Well, as Trotter told us, sounds, words, phrases, symbols, logos. The statute is a little bit more specific in its language, but in terms of common things we see, you walk down the street between here and your hotel, and every single image you're confronted with probably is a trademark owned by someone. So what does trademark do? It does a number of things. It protects consumers, because we as consumers are too stupid to be able to discern goods on our own. So the government has decided to help us with this wicked decision so that I can walk into Golden Arches around the country to find service of McNuggets that I dream for. It protects the company. It's because McDonald's dumps a tremendous amount of money into protecting their Golden Arches, and we don't want We don't want someone like me who scored -6 in homemaking skills many years ago to come along and open a restaurant with hamburgers and call it McDonald's. It avoids confusion. It allows me to know that if I see McDonald's or Quality Inn, I am dealing with a real McDonald's or Quality Inn. It legitimizes sponsorship, and by this I mean if an entity is sponsoring the organization or the event. For example, Chicago, Kent, and CALI present the 1998 CALI Conference for Law School Computing. Sponsors are Lexis, Westlaw, other organizations like that. You know that that is the real organization involved and not a ripoff. And finally, there was an amendment to the Trademark Act several years ago to prevent tarnishment and dilution. And what this means is you can't make the mark look bad. That's basically what it comes down to. For example, if you're going to use someone's mark in a way that it demeans the mark or shows that the mark, that the company is bad or the company is somehow involved in something illicit, and why on the law school side you'd have this, I'm not really sure about. If you were to go that direction, you'd probably be in more trouble. Misappropriation is a little bit less formal than trademark law. Misappropriation deals with taking something that's not yours, somehow making people think it's yours. This can deal with people's images. It can deal with people's voices. It can deal with words, symbols, and logos that have not raised themselves to the level of trademark protection, but somehow get other property rights. Again, going back to this idea that everything is owned by someone, and unfortunately it might not be you. Again, it protects consumers so that if I hear the voice or a song being sung by a particular individual, I know it's really that individual and not myself impersonating them and booming out some bad version of Two Live Crew. Although that is an amusing thing to entertain for a moment. It prevents you basically from benefiting unfairly. Often celebrities employ misappropriation type claims. They have worked very hard to raise their image, to have their name, their likeness, everything be able to earn them money. So we don't want someone benefiting unfairly from that. Okay, so the dilemma is, do we just do it or just don't do it? And this is the decision that I suspect that many of you are faced with. You're given a block of material from your faculty member, and you're not quite certain, should I put it up as they say? Do I need to go back to them and ask them if they've gotten permission? It might be August 1st, and their class starts August 14th, and this professor is just one of 35 that you have to create a web course for. Where are you going to start drawing the lines? How can you sleep at night? All right, this is what you have been given. This really looked cool on the website, but when I blow it up to so many pixels, it loses a bit of definition. But this is the DC comic Batgirl. So if you receive this, what's really on this site that you're not getting is an entire screen of legal language from Warner Bros. That says, you better not. Don't think of it. This is ours. Don't come near it. Get your cursor and cut and paste away from me. Maybe they make it this bad pixel just so you are frustrated, although I suspect I could clean it up with a few decades of work. But you need to recognize that most of these sites have some legal page, whether it's hidden or whether it's obvious. The Warner Brothers page actually was pretty obvious to find, and it was very broad-based. All right, so you need to assess the risks. Who is your audience? Are you putting a web page out for a single course that's going to be landlocked within your school, and you're very, very, very certain that no one outside the school is going to get to it? That's different than if you're putting out a web page that a lot of faculty do where anyone in the universe and beyond can click on that site and see material. That's one of the things. You're assessing what's your chance of damaging, what's your level of harm here. What's the likelihood of confusion to occur here? Are you using this as an educational sort of method such that people will recognize, I am showing these logos to teach you about trademark law, or am I showing the logos to perhaps suggest that our school is sponsored by Nike, because we're fast students who run really fast? And what's the eventual harm to the mark owner? These are the reasons. To some degree, mark owners zealously protect their marks because to let you slip through is to open up the floodgates of evil. Not that you are evil, but perhaps evil is being caused on your website. So the question is, what is the harm that's being done? How bad is that harm on a continuum? And these are the sort of things, factors, that you can use to assess the risks here. And then finally, if you want to avoid the problems, basically the method is to know the rules. Know as much as you can. Get as much information from your faculty member. Institute policies ahead of time so people know permission is the safest way to go. Thank you.
Hi, my name is Mary Dicig. I work for Gardner, Carton, Douglas. I was a law student at Chicago, Kent, and I worked for CALI for years planning, I think, the first 2 or 3 conferences, mostly the social activities, lest you think it was anything substantive. I specialize in internet and computer law. I spend a great deal of my day trying to keep my clients out of court. In the event that I do get into a court situation, I try very hard to get them out before you go to trial. It costs a lot. A lot of my clients are authors who decided it's on the internet, I work for a university, it's probably fair use, and if it's not fair use, what are they going to do? Are they going to sue me? Well, my answer to that, I mean, number one, yeah, they can sue you, but we all know how expensive it is to raise a lawsuit. So, okay, they got a point. I'll give them credit for their licenses are, you know, a lot of people are not going to sue for infringements. But in 1997, December of 1997, Congress passed the No Electronic Theft Act. The No Electronic Theft Act encourages prosecution of copyright infringers who do not profit from their infringement, like law professors. It adds criminal penalties of imprisonment of up to 1 year and fines of up to $100,000 for infringing uses of at least one copy worth $1,000 and over. It adds felony infringement provisions for infringing uses of at least 10 copies with a total retail value of $2,500. Retail value is left to be interpreted by the courts. So this is a brand new statute. There's reason not to infringe, so just something for you guys to think about. And it's already come up in one of my cases, so this, I expect that this is probably going to be widely applied. Okay. Just to note, in the case of works that were published with the support of the federal government, there's a real good chance that that work, you can use that work without clearing the rights. The federal government doesn't hold copyrights in its works. There's a provision in a lot of grants that say any work that you do with this will be the property of the federal government, and United States citizens have certain rights, including the right to copy such work. So keep an eye out for that. A lot of times the legends, if you're taking it off the internet, there'll be a legend that says government rights, a little button usually. Okay. Thank you for going through the fair use factors. My goal is to get this over with in like 3 minutes, so excuse me if I go really fast because we need to leave time for questions. I'll go through them real fast. Fair use factors: the purpose and character of the use, mainly commercial versus educational; nature of the copyrighted work, factual versus the amount of substantiality of the portion used, and the effect on the market. Okay, in light of that, there was a case called American Geophysical Union versus Texaco. It was a scientific researcher at Texaco who copied 8 journal articles to keep in his archival library. You'd think, fine, there's no problem with that, that's fair use. Well, it's not fair use. The court said the issue is whether or not all of Texaco's 800 scientists can do the same. Texaco had 3 subscriptions to the particular journal in question. It was something like the Journal of Ceramic Coatings or something like that. Texaco argued fair use because the purpose and character of the use was for spontaneous copying. The professor said the reason he wanted it was so he wouldn't have to walk into the lab with it and the journal might get chemicals spilled all over it and get wrecked, and on and on and on. So the court, that was his first argument. Next argument was the nature of the works are factual and thus not entitled to copyright protection. Third argument was the amount of copying should be considered only in the context of whether a copy supersedes the demand for the original, i.e., is anybody going to want the original manuscript of this? Will you pay for the manuscript of this outside of the journal? I think not. So that was their argument. The fourth argument was Texaco would not increase its subscriptions to the journal, even if the scientists weren't allowed to copy, because they got a budget and they're going to stick to it. The court said, Hui, that the purpose of the use was archival as an addition to a scientist's library, and the court did not wish to encourage such copying, and thus the first factor weighed against Texaco. Now the reason I bring this case up is we all know fair use is eroding, and I don't know that it's going to happen, but I can just see the day when law schools and graduate schools of men and other schools, professors don't get to keep copies for their private libraries. Okay, the nature of the works are essentially factual. Yep, they got a point on that one. Texaco copied entire articles, and they're wrong, and they don't care that nobody would have bought the manuscripts from the original authors. And the effect on the market, usually this factor is pretty important. Well, in the case of academic publishing, they said the effect on the market is of limited significance, where unsolicited articles are published in journals without recompense to authors. So in this case, the court said Texaco can have it, and even though it's usually weighted pretty heavily, we're not going to weight it heavily in this case. Like Trotter said, these analyses are kind of a I know it when I see it kind of thing, and it allows essentially Texas courts to go against everyone else in the country when they weigh factors in favor of plaintiffs or defendants who are from Texas. So that's what happened in this. They ruled, for the fourth factor, they ruled differently than had essentially been commented on by the Supreme Court, and they said the fourth factor is not a big deal when it is academic use, and that was cert denied by the Supreme Court. Next case is Princeton University Press versus Michigan Document Service. This is an extension of the Kinko's case where you're talking about course packs. This case pretty much followed Kinko's except for one thing. The court made a comment that if the course packs are reproduced by a not-for-profit company for the students, it's probably okay. So if Kent decided as for a not-for-profit purpose to go ahead and make these course packs, then that would probably be okay. And if anybody wants the site for that, it's 99 F3D 1381, and it was the Sixth Circuit in November of 1996. So that's the thing that I thought that was interesting on there. Next case that would be relevant to authors and publishers who use internet stuff or just electronic-based stuff is Los Angeles News Services versus KCAL TV. This was the Reginald Denny beating case where KCAL TV took a portion of the footage and rebroadcast it. The court said because, even though it's factual, even though it's news, because Los Angeles News Service is in the business of selling its news, that this was an infringing use. Let's see. They found the purpose and character is for the plaintiff and that KCAL TV sells its news and services for profit. Nature of the work was in favor of the defendant because it is news and it's factual. Amount and substantiality weighed in favor of the plaintiff because what was copied was a substantial portion. And the effect on the market weighed in favor of the plaintiff since free and uncontrolled use would destroy plaintiff's market for the tape. So that's kind of like the standard is free and uncontrolled use. If it was completely uncontrolled, would the market be destroyed? And that's how they look at the fourth factor. Another case I thought that was interesting, it's not a fair use case, but it might be relevant to authors. It's Playboy Enterprises versus WebWorld. WebWorld took pictures from news groups, and they offered, as a subscriber service, they offered people access to getting these pictures. They happen to be Playboy pictures, but that's not relevant to the inquiry. The court held against WebWorld and said it's not fair use, even though they got it from a news group where it's completely uncontrolled. WebWorld tried to argue it's similar to RTC versus Netcom, where it's just an internet provider. The court said, no way, you're taking the pictures. People get internet access even before they go to your site, so you're wrong there. And WebWorld also said it can't be held liable because it has no control over what's posted on the news group. Well, the court said no to that too. So if you get information off of a publicly available free source on the internet, be careful about where you get the information from. If it looks like something that you should probably get copyrights for, you or clearance for, you probably should. One thing I want to tell you about rights clearances, I do a lot of rights clearances. Sometimes there's stuff where you just can't find the rights. There's just no way, you can't trace it. And this is a fair amount of stuff. In general, go to the Copyright Clearance Center. If it's not in the Copyright Clearance Center and you've looked at all the other obvious sources, you guys might disagree with me, but in general, I think people are at relatively little risk of copyright infringement. That doesn't mean you can only go to the Copyright Clearance Center. But you know, if you have something and you really need it and you really, really tried and you have checked copyright clearance, you'll probably be okay. But use it, because courts are starting to use Copyright Clearance Center as a factor in a lot of the cases in determining whether people can make money off of it. Because even if it's something you'd never think anyone would want to look at, if it's registered with Copyright Clearance Center, that means that the author holds a value to it, and if somebody did buy it, there would be royalties paid on it, and if it were used uncontrollably, there wouldn't be royalties. So check with Copyright Clearance Center, because that's cropping up in a lot of cases about whether or not they checked. I just want to mention briefly about linking. There's two kinds of linking. One is linking to a site, and the other one is linking so that content from somewhere else on the web appears as part of your site. Second example is more egregious. Obviously, don't do that. First example, linking to a site, just be careful how you link. In general, there will be a button. It'll be under terms and conditions. Sometimes it'll be a hot link to copyright. They'll give you information on what you need to clear links. You can't assume that you can link. A big part of my job is writing rights policies and writing linking policies for a lot of companies. One of my companies publishes schematic diagrams of the things that it sells, and you can link to it, and we had a competing company who linked to it in a comparative advertising manner. The company who linked to it got in a lot of trouble. They paid us a lot of money, and they had to remove their internet site. Because one of the reasons this was so troublesome was not that the comparative ad was bad, but because they violated our license or our policy for obtaining permission to create links. So scope around the website and look for the legal language, because you might find out where to go, you might find out what the conditions are. And for academic purposes, people are pretty good. The prices, I don't know if Susana has found this out or not, but in my experience, the prices for academic publishing are a lot lower than the prices for commercial publishing, significantly lower. For instance, a lot of textbook publishers they have something called permission fees, and it's a whole lot lower than royalties. And so if you're looking for rights clearances to put in a course pack, just call them up and check out whether or not they have any permission fees, because it's really pretty cheap to do it for academic use. Let me think what else. There's one case, Judge Zagel's supposed to publish his decision pretty soon. It's someone who reproduced shareware. You'd think shareware's up there, it's no problem, it was unrestricted, it was free. Well, that's wrong. But I don't have the site for that because I just found it right before I came over here and didn't have time to write it down. So look for the opinion on that, because it's going to be pretty soon. That's it. Okay, I'm a little...
We have a few minutes here if there are any questions. Yes.
Me? That's a really tough question. There is no specific case on that issue. However, a company is responsible for information posted on a company website by its employees. So, in an extrapolation of that, I would tell you yes. If you were to come to me for a legal opinion, I would say yes.
Well, the conservative advice, I give this advice to people who have questions, is never leave your own bathroom. And then you're okay, right? You can't do anything wrong. But anything else, you run a risk. The likelihood that students would do something that would make the university liable is a really hotly debated question, and universities worry about it. The argument is slightly less strong than for faculty, because faculty or administrators, because they're clearly employees, and most of the doctrines about making an employer liable relate to what the employee does. Students are not employees in their capacity as students. So there's less of an argument, but nobody really knows. And what I'm sort of proposing at our university is that we create a logo that says academic freedom. And if you post this on your page, student or faculty or administrator, what that says, and someone clicks on it, what it says is the university is not responsible for this. People are free to do what they want to, and we won't check it. I have no idea if that would carry any legal effect, but it's just a useful thing, I think, to do.
Yes.
Sort of not the same thing, but it's related. We had a student at our university who sent out a couple of software packets to a neighboring university, which basically crashed a lot of the neighboring universities' workstations in their IT department. Ha ha ha, wasn't this fun? And there was quite a bit of legal wrangling between our university's legal department and their university's legal department as to whether our IT department took precautions, significant precautions to prevent this sort of thing from happening. And the decision is whatever they're wrangling, they are still wrangling. So that sort of thing. It's a little bit different than what you asked, but it's
There's no obligation, I mean, you're not implicating any sort of infringement thing. This is, in general, a tort case, and there's no obligation for you to take significant precautions other than what is generally used in the industry. So as far as, is anybody liable for this? No. And this is exactly the kind of case that I think would just be hellish if it were to get into a court. It would be fact-intensive and one that judges would just hate. And both universities would be, it would be a good idea to just make friends now. Yeah. The kids, on the other hand, I mean, they could get in a fair amount of trouble if they did this maliciously. Yeah.
It used to be a fairly consistent rule in this country that employers were not liable for the intentional wrongs of their employees, only for their negligent wrongs. So if someone deliberately, if an employee deliberately did something bad, usually the employer was not liable. That's changed. The recent Supreme Court decision about sexual harassment, I think, is actually a statement that employers can sometimes be liable for the intentional wrongs of their employees. And if that's expanded, it could expand to many other contexts besides harassment. It could expand to student conduct or faculty conduct causing harm to someone else, even if it is intentional. The university could conceivably be liable for that. Are you calling on folks? I don't know.
I was struck that to talk about a range of IT things, so appropriate in the trademark and misappropriation. What was occurring to me as I was sitting there watching it and thinking, trying to muddle through how you're supposed to deal with it. Is there a way to kind of approach the question that helps you kind of categorize what you're supposed to be looking for? That means something like trademark. Other things something like copyright. I realize copyright is more different subject. Everything is how do you characterize what it is that you're supposed to think?
Yeah. Well, the trademarks and copyrights can overlap. I mean, for example, a company can have a little image that they use as a logo, but it could also be a copyrighted drawing or a photograph. So what you have to ask is, how is it being used? Is this thing being used primarily to sort of identify the company or whatever, and it's used as a trademark? Is it not used that way? It's just a freestanding sort of drawing or piece of text, and it's probably copyright. But they certainly can overlap. They can coexist in the same work.
To some extent, what I do actually is I have a little checklist, and I think, where are all the places in the site that I have sound, images, text that is not original to the author, anything like that, and then I go through and say, is this sound protected by trademark law? Is it protected by copyright law? Is this image such that it's protected by copyright law? Is this image also protected by trademark? Because there is overlap. And cartoon characters are the easiest to think of, actually. They usually are protected by both, because they have such wonderful personalities, plus that art stuff that goes with them. So there's a great deal of overlap, and what I really gave you was, if you threw a stone in the water, I was a single ring in our puddle of mess. Yes?
Being handed material, we just have to go through the checklist or evaluate a policy that the university has to semi-automated or completely automated process. Which end of the spectrum is there potential criminal liability for the
Oh, well, I mean, the techie is somewhat protected in that if you are simply following out your university's instructions, it's your university who needs to take responsibility for giving you instructions that are not going to violate the law. So the techie, I would argue, who is an employee, doesn't have all that much liability for this kind of thing.
No, I mean, in theory, you're liable, and we were talking about the question of is the university also liable. In practice, the people are going to sue the deep pocket. I mean, they're not going to sue an individual tech person if they can sue the university. So as a practical matter,
I mean, practically speaking, a university, it's possible that depending on what the use is, the university is going to be fair use.
right? But you're also worried about the criminal provision, right? Well, in which case they can't. I mean, they would go after you, I suppose. I don't know the criminal. I know the provision you're talking about is fairly new. It used to be that in order for anything to be criminal. For criminal liability, you had to be selling stuff and making money. And what the change was, I think, and you can correct me on this, is that you don't have to be selling it for dollars. You can be selling it for barter. Because the case was where a guy was encouraging people to put software on his site, commercial software, and in exchange he would put software or something like that. And technically at that time that wasn't criminal liability because he wasn't actually selling. Now that would be criminal liability, but I think there's a still notion that you have to be making something from your activity, either money or barter or some favor. So if you're just putting something up on the web and not asking for anything in return, I don't think, I'm not sure, but I don't think you can be criminally liable.
That's true. The statute, the words of the statute are receipt or expectation of receipt of anything of value. However, the commentary along with that adds in that things of value can be enhanced reputation, all kinds of things. So it's pretty broadly worded, but as a techie, I don't see how you, unless the university said, I'll give you $1 million more salary if you put this up. Yeah. I don't see how you personally would be liable. There's also a limit on the amount. Whatever you put up has to have a total retail value of at least $1,000. That's a pretty huge safe harbor. So,
I think we have time for one question.
It's reasonably conceivable that I can go through and keep a track of a large portion of the website that my school might have. But, however, I've had an email account for 8 years, and in those 8 years I've received at least 4 or 5 copies of Monty Python script for the Holy Grail. Now that's copyrighted material. I've received it, I've read it, I've broken the copyright infringement law. How can I protect myself against students distributing that to each other, distributing pictures, things like that? That's all on my system, on the university system.
You didn't break any laws. It's distribution. That's the key thing. If somebody gave it to you, pardon me?
So the students of the school are distributing to each other these materials. Does that make the university liable?
Probably not, and certainly not if a bill that's floating in Congress right now near passage. It's the digital millennium, blah, 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 blah. But one of the things it says is that essentially ISPs are not liable if they meet certain conditions, and basically if they don't know, it's mechanical, they're just providing the equipment. So if that bill passes, and I expect that it will probably fairly soon, then you've got a real nice safe harbor as the manager of the information structure.
Provided they get, they're not technically ISP, so provided the law provides for.
I'm not sure if they meet the definition. You don't think so?
No, and the definition of an ISP is if you did not have the service of an ISP, you could not access the internet. So, and in general, all they're doing is providing access to a university service. But that's not the ISP. The university would have the ISP. So I think there is some minimal liability on the part of the university. I think a good rule of thumb is if something bad happens once, shut it down and stop it. I can't remember the name of the case, but there was a defamation case involving pretty much a similar issue. And the court, I think one of the things the court had hinged on was this had happened a couple other times and they did nothing about it. So if you have an incident once and you take action promptly, and if you are notified of an incident and you take action promptly, as with any infringement, your liability is considerably lessened. I mean, I know that the answer is draconian. To stop allowing students to use the internet and post things to websites is just, that's kind of dumb. But
Yeah, but the other thing, the practical thing is if someone comes to you and says, I've got all these copyrighted images and they're up on your website without my permission, you should definitely take them down.
Immediately. I mean, don't say, well, we have to check it out. Take it down. You can always put it up if it's wrong. Just take it down right away. Matthew Zeidenberg versus ProCD, the amount of time something remained up on the site was a real critical factor after notice of wrongdoing.
We're going to have to stop now because of lunch. Thank you all very much.
Thank you so much. Lunch. Oh, I would love to. Lunch.